Okay, welcome back. The next panel focuses on financial firms and really the heart and soul of SEC regulation. We're talking about asset managers, broker dealers, hedge funds, and other regulated entities. And moderating the panel today is a seasoned pro on securities enforcement, Peter Altman. Peter is a partner at Akin Gump, who also previously served in the SEC Enforcement Division in Los Angeles, and also was a member of the Market Abuse Unit. Great having Peter on this panel. He's been on it before. His practice really focuses on representing investment management firms and investment advisors on day-to-day risk management issues, related to securities trading and compliance and data security, and more. So thanks so much for being here, Peter, and for moderating. Welcome.
Thanks a lot, Bruce. Great to be here.
Next, let me introduce Jennifer Hull. She's a managing director at BRG. She focuses her consulting practice on areas including forensic investigations, financial statement analysis, and compliance, and is a CPA and also accredited in business valuation. Jennifer has significant audit experience with entities such as hedge funds and the other types of financial firms that the panel will be discussing today. So great to get your consulting perspective here today, Jennifer.
Thanks, Bruce.
Let me next welcome Kristin Snyder from the SEC. Kristin wears many hats. I would like to see Kristin's business card. It probably has a lot of text on it. She is the Deputy Director and Co-National Associate Director of the Investment Advisor Investment Company Examination Program in the SEC's OC, Office of Compliance Inspections and Examinations. In addition, Kristin is the Associate Regional Director for Examinations in the SEC's San Francisco Regional Office, where she leads the examinations program. But her past experience as an associate, her current experience as an associate regional director, her past experience as an enforcement lawyer really helps her look at these issues from both sides of the coin, regulatory and enforcement. So we're really grateful to have Kristin here. Can't wait to get her very complete perspective. So thank you, Kristin.
Thank you, Bruce.
Finally, I'm pleased to introduce Sam Waldon, who's a partner at Proskauer. Sam previously served as Assistant Chief Counsel in the SEC's Division of Enforcement for 8 years. His practice focuses on securities litigation, enforcement, and regulatory matters, and he regularly counsels financial firms in SEC enforcement matters. Sam, really looking forward to hearing from you today. Welcome.
Thanks, Bruce.
All right, Peter, let me turn it over to you.
All right. Thanks again, Bruce, for that great introduction. It is great to be back here. This is such a terrific collection of panelists. Let's jump right into it. So our first topic today, we're going to talk a little bit about the fluid market dynamics that we're all experiencing and what investment advisors might expect out of the examination function in 2021. So to set the stage, a couple of months ago, the SEC's Division of Examinations, as it's been rebranded, put out its annual report on examination priorities. Needless to say, this report, along with all of the other public commentary and risk alerts from the division, which has certainly been a prolific publisher since the start of the pandemic, gives investment managers and their counsel a lot to think about. So Kristin, let's start with you. Start with the SEC, we'll finish with the SEC. I'd like to focus on how the division sort of considers these changing market dynamics and systemic risk when it approaches day-to-day work of examining investment advisors. Of course, over the last few months, there's been so much talk around meme stocks, SPACs, ESG, to pick some headline grabbers. And earlier today, we heard a really great discussion between former Commissioner Gallagher and Professor Grunfest, which touched upon so many interesting topics in this area. So Kristin, does the Division of Examinations take a different or nuanced approach to issues that come up during exams that touch upon matters that are sort of subject to current public debate and developing guidance from the Commission?
So first and foremost, thanks for having me. Thanks to you and to Bruce. And I have to just give our quick standard disclaimer. I know that the prior panel gave it, but I'm conditioned to do it. So I'll just say that the remarks that I make today on the panel are my own. They don't necessarily reflect the viewpoints of my colleagues on the commission staff, the SEC itself, or our chair and commissioners. And so with that out of the way, and just setting the stage a little bit, our Division of Examinations really kind of functions as the eyes and the ears of the commission. So we've got staff out in the field who are hearing about often new products, new services all the time as we conduct examinations. So I know sometimes those things are hitting the press, with a number of the issues that you highlighted. But I would say, I think our exam approach doesn't necessarily change. We are always trying to learn more about any new products or strategies, how those will impact investors. If there are market events, of course, we want to understand those better through our exam process, engaging with registrants. But we're ultimately following the same rule book. And so there may be policy issues that pop up with, new products, services, and market events. We will often, consult with our colleagues in other divisions, that set the policy, and especially if there are kind of gray areas around any issues. But I would say, kind of fundamentally, the exam process doesn't change. We will dig in and maybe try to learn more. Certainly if new issues or events pop up. And I think a great example of that is, just at the beginning of the pandemic, when we were all transitioning to remote work and it was somewhat unprecedented, we conducted hundreds of outreaches to firms just to find out how firms were transitioning. And we often did so, in collaboration with and in coordination with our policy counterparts. So in the case of asset managers, often, we were reaching out to firms, and we had colleagues from Division of Investment Management on the phone with us. And that helped drive, I think, some of the relief that was granted, because from the policy perspective, Division of Investment Management was kind of hearing in real time the issues that were impacting firms. And then on our end, in the exam context, it was very helpful for us to be able to inform our stakeholders within the commission as these issues were coming up. And so I use that as an example. If there are other market events, I think it wouldn't be unexpected for us to be reaching out to players in the market where we think there might be greater impacts, just to get maybe a real-time kind of response. But ultimately, I think the exam process, you'll find, especially if firms are being examined, will remain the same, although we may want to dig deeper in areas where we're learning more.
Some of our clients were on receiving ends of those phone calls early in the pandemic, and I will say, when calls like that are made, where you're just sort of reaching out to try to get information, is there an attempt to kind of message the purpose of the call? Because I think, just speaking from some of our clients' perspective, it can be confusing when you're hearing from the examination function, there's policy people on the line as to really what the purpose of the call is. Is there thought given to that type of messaging?
Yeah, I can't speak to all of the calls that took place because there were many, but I know that the calls that I was part of, I think we were pretty clear in terms of why we were reaching out. And when we're talking about outreach, often the phone calls were under an hour, just to do some very high level check-ins when things were happening. So it's certainly our goal, to be as transparent as we possibly can be in a situation like that. And at least the calls that I was part of, we were pretty clear, here's the reason why we're reaching out. And we found them extremely helpful. We got good feedback, I think, from a number of the folks we reached out to. I don't know if they were just being nice, but it was a good way, I think, for us to share information very quickly.
I think that's the proverbial captive audience on the other end of the phone. One more question, Kristin. There was an announcement last summer regarding the Event and Emerging Risks Examination Team that was deployed, and I don't know whether that was in response to the pandemic or if that was something that was pre-planned. What role does that team play in being the kind of like eyes and ears, as you put it, of the division out there in the marketplace?
Yeah, so we call it the EERT because it is kind of a mouthful when you have the whole name, but it's a multidisciplinary team, and I think it was put in place to really complement all the, it's a small team, so it was really put in place to complement the work that we do across all of our regional offices and with our exam program in Washington, D.C. And, it includes quants, it includes folks with an information security background. And then we have some experienced examiners and people with industry experience, really covering all of the 5 program areas that we have in the exam program. So again, it wasn't, I think we will periodically look and see, are there ways that we could strengthen our program? And I think, we already have, I feel, a very strong program across the country, but this team was kind of put into place to really, help us look around the corner, address any risks that may come up on an exigent basis. So if there's a big cybersecurity event, that team may conduct, examinations or conduct outreach in the first instance. And you would think that maybe it came about in response to the pandemic, but it was actually something that we had in the works. It takes a little while sometimes for these groups to get up and running. So it was something that we had thought about and started to put into place before the pandemic hit. Would have been really nice to have that group in place, I think, as the outreach was conducted, because there's some pattern recognition. I think, if you're doing an outreach call or an examination on a particular issue in California, it may look very similar in New York. So that team is led by Adam Storch, who has been at the commission in various stints. A couple of times he was in our enforcement program, and then prior to taking over the EERT, he was doing a number of special projects for our director, Pete Driscoll, and he also comes with a lot of industry experience. So it's been very helpful. But I think, again, that group will help us think through risks and look around the corner, and they will be out in the field, and they'll often be in the field with regional teams. And so I think if registrants are encountering the EERT, you're also likely to be working with whatever regional staff covers that particular examination.
That's great insight. Thank you. So Jennifer, I think in your One Big Thing video, you talked about recent market events associated with Archegos Capital. Can you give us a little bit of background on the specifics of what happened there? Obviously, it's been kind of all over the news, but there's, I think, still some lingering confusion around exactly what was happening. And then maybe give a comment on what you think will be the longer term impacts of that situation, particularly for the registered IAs that are out there deploying capital in the swaps market or using leverage more extensively.
Okay, sure. First, I'll give an abbreviated recap of the incident, and then I'll touch on some of the resulting conversations that we're hearing in the industry, and I think that'll cover all those points. There was a market disruption in late March that is continuing to get a lot of press and attention from regulators around the world. What was first noticed is that some big stocks took a substantial hit to their share prices. Shares of Viacom and Discovery dropped 27% on one trading day. Share prices in other less well-known stocks also experienced similar declines. And soon it was revealed that a family office called Archegos was at the center of the market disruption. What they had done, they had accumulated large investments in stocks such as Viacom and Discovery, also a Chinese vaping company, some Chinese technology stocks, and a few others. But the way that they had made the investments was through total return swaps with multiple bank counterparties. And under the swaps, Archegos had borrowed from the bank counterparties, and the banks used the borrowed funds to invest in the basket of stocks on Archegos' behalf. Archegos paid a fee, they were paying their interest to the banks, while the banks paid the return on the basket of stocks to Archegos. The fund was profiting as long as share prices were rising, but certain of the share prices fell, Viacom, Discovery, which caused the counterparty banks to issue margin calls to Archegos. Then Archegos failed to meet the margin calls. Then the counterparty banks started to sell the stocks. The bank's liquidation of $20 billion worth of these various unwanted stocks caused the share to dramatically decline in certain instances. And really, it was a race to liquidate. The counterparties that were able to sell the fastest experienced the smallest amount of losses. And after the sell-off, the investment banks, they've revised their loss estimates a couple of times, but the reported losses among 6 of the banks is still in the range of $10 billion. Goldman Sachs, Morgan Stanley, UBS, they were able to sell their positions quicker than, say, Credit Suisse. So Credit Suisse losses are the largest at $5.5 billion. Share prices of the banks fell, particularly Credit Suisse, and Archegos is insolvent. So it was quite an incident in the markets. And with that chain of events, There are lots of Archegos-related topics to cover. So I'll highlight just a few of the discussions and questions that we are hearing in the industry. First, the man behind Archegos was accused of insider trading in 2012, paid $44 million to settle the claims, and he was prohibited from managing money for clients. For that reason, some industry professionals are asking why the brokers did business with him despite his history and despite his reputation. There's one big question. There's other questions that are being asked, like, should the investment banks have at least limited their exposure to Archegos? Were the banks able to obtain enough access to Archegos? Were they able to even get enough information so that they could adequately evaluate the level of risk to which the family office was exposed? And now, should these investment banks be reviewing their business with other family offices? And then you have a separate topic of family offices and the fact that the extent of Archegos' investments were not known. Family offices that meet certain criteria are exempt from registration. They don't have to file a Form PF. And through these total return swaps, Archegos did not have to report its positions in shareholder filings. So this all has some industry professionals questioning whether there should be more or better data on the role of family offices in the market. And then, but also many people are asking, and this is what I'm hearing the most, how was risk management at Archegos lacking such that it could overextend itself without having capital to fall back on? In my experience, the incident is causing funds to revisit their risk management practices and their internal controls concerning the use of leverage and margin. Investors are asking their advisors about how robust is their derivatives risk management program. Likewise, I think fund managers are reviewing their leverage-related disclosures to investors. They're looking at whether the fund's use of leverage matches its risk profile. Also, whether the fund's disclosures convey the impact that liquidity risk and leverage can have on the viability of the fund. And also whether the fund's disclosures describe how much flexibility the fund manager has with respect to leverage risk. And then, of course, probably the most frequent Archegos-related discussion topic is speculation about how the regulators are going to respond to the market disruption that was caused by Archegos. So, and then, Peter, I'll stop there and pass it back to you.
Yeah, no, it's great perspective, and it certainly is an evolving situation. So, Sam, at least in our experience at Akin, I feel like getting clients ready for conversations with the SEC, whether it's in an examination or an investigation, around topics relating to risk management, and sort of how they're handling issues along these lines that Jennifer was just describing, getting them ready for that conversation is difficult because products vary, personnel vary. There's just a lot of nuances that come into the situation. What has been your experience here with your clients? Have you had to work through kind of framing up or explaining any tricky issues relating to risk management? And what's been the response that you've seen?
Yeah, thanks, Peter. And that is one of the, there's so much with Archegos that is yet to be known. But one thing is clear. Clearly, there was a massive failure of risk management, and it does raise an issue that we have seen, at least in one exam that I worked on, helped a client with recently. And it's the question of what is the relationship between risk management and compliance? And I think in the abstract, the answer is arguably no. There's no relationship at all. And that's because there's no federal securities law that prohibits an advisor from taking on excessive risk or making bad investments. And the compliance rule only requires an advisor to have policies and procedures that are reasonably designed to prevent violations of the federal securities laws. The problem is that almost every advisor at some point in some way makes some disclosure, some representation about their risk management controls and how great they are, how they only hire the best people. And once you do that, at that point, then risk management does become subject to compliance. Because if you're making representations and not living up to them, there's at least arguably a violation of the anti-fraud provisions of the Advisors Act. So with that understanding, I think it's important for counseling clients to understand that compliance does have a role with respect to risk management, but it's a somewhat limited role. First, because it arises out of a disclosure issue. And so what compliance is responsible to do is to make sure that the risk controls that are in place are as advertised. And also, the compliance rule requires only that policies and procedures be reasonably designed to prevent violations of the federal securities laws. They don't have to be perfect. And so while compliance definitely has a role in reviewing the risk management controls, it's not the case that risk management becomes compliance responsibility. And it's not the case that compliance has to go in and evaluate the adequacy of the risk controls. In the case that I've worked on, the trading strategy involved complicated derivatives. It literally would have required the CCO to get a PhD in mathematics in order to effectively evaluate the effectiveness of the risk controls. So with that view, I think what we tend, the way we advise clients and particularly CCOs is make it clear they have to understand compliance is responsible for reviewing the risk controls. There have to be testing done to make sure that the risk controls are in place, that they are as advertised. I think the CCO can rely on and has to be able to rely on the professionals who are actually managing the risk controls, but that reliance has to be reasonable. The CCO has to have a reasonable basis to believe that the folks who are running the risk controls are qualified to do it based on their background. And they also have to be confident and have a reasonable basis to believe that the risk controls are actually being implemented, that folks are showing up at work and are running tests and doing the things that you would expect to see from risk management. And the last thing that we tell our clients about this issue, and it's advice we give almost all the time with any compliance issue, and that is the importance of documentation. And the importance to document that compliance has been testing the risk control, has been confirming that they are in place and they are as described. And it's also important to remember that this is only going to be a really big issue for an advisor when something catastrophic happens at the fund. See Archegos. And so when that happens, it becomes really difficult to be able to distinguish whether the catastrophic event was the result of a failure of the risk controls, which I think is outside of compliance, or was it a failure to implement risk controls that, if they had been implemented, would have avoided the problem. And so I think it's important, and what we advise clients is it's really important to document that you're able, that you're doing that so that you're able to establish it down the road.
So Kristin, I feel like that's like the natural boomerang back to you. So documentation, it's in the advisor's files. What are examiners really looking for when they come in to conduct an exam and are looking at risk management policies, and kind of just broadly, but also specifically to more exotic financial instruments like swaps that are in the portfolio, other derivatives, things like that?
It's a great question, and I wish I could just clone Sam's answer, because a lot of what Sam touched on, I think, is what our examiners will come in and take a look at. And the most important part of the punchline, I think, too, is just the documentation piece, which I can't stress enough, because I think especially with a newer product, just making sure that you can demonstrate that the firm kind of understands what the risks are, that there are processes that have been developed, kind of to help mitigate some of those risks, or just that, the processes are well implemented is really important. And then always important, I think, to continue to do periodic reviews to ensure that the procedures are sort of working as planned and working as expected. And, I take Sam's point, we're not expecting chief compliance officers or the compliance program to understand all the ins and outs of, very complicated products, but we do want to ensure that, I think, compliance and risk management and other parts of the organization are working together to build an effective program that is consistent with disclosed strategies, to clients, disclosed, the adequate, ensuring that the risk disclosures are adequate. So it's, kind of separate and apart. Just we're going to be looking as examiners at, what are you telling your clients you're doing? And then are your internal processes sufficient to kind of satisfy those disclosures? So I think particularly with a newer product, just making sure that it's well documented because it's hard to reconstruct, I think, in the middle of an examination or an investigation what you did. So I really can't stress that enough. And I think that's a really important point that Sam made as well.
All right. Unity of opinion from the SEC and the defense bar. I love it. Okay. Second topic for today. We're going to talk a little bit around the SEC's new marketing rule, an issue that I can tell you is a source of serious focus and still the process of digestion of that rule is happening, no doubt. So Sam, it was Tuesday, December 22nd, and just as everyone was getting ready to unplug for the holidays after what is fair to say was a very long year, the SEC sent out an email with the subject line, and I remember receiving this in all caps: SEC adopts modernized marketing rule for investment advisors. And it probably should have also said, happy holidays, everyone. And you could imagine all of these big firm lawyers and CCOs out there trying to get their home printers to work, printing out hundreds of pages of new rules. And with that, we had amendments to Rule 2064 were now with us. And those amendments have just become active as of last week, May 4th. And we could probably devote a whole day to talking about the ins and outs of the new rule. But can you give us some insights on the major changes and really why this is so important for practitioners and managers out there?
Sure. And it's only a 400-page adopting release. And I've been told I've got 4 minutes, so it's 100 pages per minute. I think I can do it.
I hope you printed double-sided. Okay, go on.
At a very high level, what the new marketing rule does is it takes the old advertising rule, the old solicitation rule, combines those two together, takes a number of no action letters, prior staff guidance, best practices, puts it all in one nice basket. Structurally, a lot of changes. I think substantively, not a ton of huge changes. There are some changes to the anti-fraud provisions, and I'll talk about a couple of those in a minute. The new rule allows for testimonials. That's something new. There's a new, broader definition of an advertisement. The rule makes it clear that it applies to private funds, which in the past wasn't necessarily clear, but I think most practitioners acted as if it did. It doesn't go fully into effect and does not become required until November of 2022, but there is an optional opt-in available right now. But with the one caveat that once you opt in, you're in. You can't opt in and then opt out. The changes, just want to spend just a couple minutes on a couple of changes to the anti-fraud provisions that the rule brings. There are two in particular that I want to highlight. One is that an advisor cannot include in an advertisement a material statement of fact without a reasonable basis to believe that they can provide substantiation for that fact on demand by the SEC. The rule does not require the advisor to maintain and have the substantiation at the time of the statement, but it seems like that's probably a good idea. But the thing that's really interesting is that the SEC doesn't have to establish that the statement was false or misleading in any way, which I think is a somewhat novel anti-fraud provision. The second provision that I want to highlight is that the new rule prohibits advertisements that discuss any potential benefits to clients from using the advisor unless the advertisement also includes a fair and balanced treatment of the associated risks of using that advisor services. And the phrase fair and balanced, I think, is a new one for the SEC. I think FINRA has that phrase and it has been applied to broker-dealers, but for advisors, this is something new. And so it's going to be really interesting to see how that phrase and the interpretation of that phrase is developed over time.
So Kristin, the examinations function, there was a risk alert back in 2017 on advisor marketing initiatives. IM has put out some FAQs, actually 2 questions with answers about the new marketing rule. And the 2021 exam priorities reference the division's intentions to review fund advertising for false and misleading statements. And really, I think most initial request lists that IAs receive ask for some form of marketing material, presentations, things like that, that an advisor has sent out. Can we expect any further risk alerts or maybe staff level guidance from the division as all of this takes shape with the new marketing rule?
It's a great question. And I know whenever any new rule comes out, we do try to be as transparent as possible. And so I'll just highlight one other resource that the Division of Investment Management currently has out on its website. There's what they call a small entity compliance guide. So if you're looking for kind of a quick overview, you don't have to read the 400 pages. I think it's 3 or 4 that just goes through some of the highlights, in terms of effective date, some of the changes. And so I highly encourage folks to take a look at that. It's a much quicker read than the whole adopting release. But, you raise a good point. Often when there are new rules or there are issues, we'll try to issue a risk alert. I think just given that the compliance date is 18 months away, we may have some additional observations this year. If firms are kind of all in, as Sam said, and they're transitioning to the new rule, we may have some observations that we could share. I think it's probably too soon to know yet whether exams would have sufficient observations really to put out a risk alert. In terms of guidance, we don't issue guidance in the Division of Exams because we're kind of following the law. We're not making policy. But I would encourage, if there are interpretive questions that are coming up, for any firms or counsel to reach out to Division of Investment Management. And I think for any rules, but for this one in particular, you can write into the im-rules@sec.gov mailbox. And if there are common questions that are coming up, additional FAQs could be, released. Don't know and have nothing to report on this, but from past experience, I think if many folks are having the same type of question, often the policy groups will endeavor to answer those questions.
All right, well, we'll keep an eye on our inboxes, I guess, then. So has the division seen any sort of issues of note specific to private fund advertising and marketing? And I ask the question again with the context that when that initial request list comes in, we get a lot of questions from our clients around what exactly do they want? Are they looking for every email? Are they looking for only presentations? What do they really want here? What are they looking for? Any insight you can offer on this would be great.
Sure. So to your question about what is the exam team looking for, I'd highly encourage folks, if the request is not clear or if it looks like it's extremely broad, definitely have a conversation with the exam team and kind of explain that. What they may be looking for as a representative sample, but that'll kind of vary from exam to exam. So I would just highly encourage, firms or counsel, if the firm is using counsel during the exam, really engage with the team and just establish, what they're really looking for. And they may be able to narrow it or come to an agreement on what would be sufficient for purposes of the exam. I think you were alluding to, were there any changes or different types of observations that we were making during the pandemic in the marketing advertising space with private funds versus pre-pandemic? And I would say no. I think we do take a broad look when we're doing our private fund exams. We're looking at DDQs, we're looking at pitch books, we're looking at performance reporting, anything that's going out to investors or prospective investors. But many of the deficiencies and observations that we've seen have remained pretty consistent over time. So I thought I would just highlight a few. And I know we're limited on time, so you can cut me off at any point. But I think, some common findings in the private fund space related to sort of marketing and advertising are just reporting of track records. We're often seeing that advisors are failing to disclose material information when they're presenting the track record of a portfolio managed by the advisor's personnel, while that personnel was in another firm, or they misrepresented aspects of the track record and didn't, comply with, kind of requirements in doing so. And so one case that I would highlight was issued in 2020 by the SEC after an enforcement investigation. And that case is called Old Ironsides. And so I think it does a good job sort of analyzing, prior track records. So would highly encourage folks to take a look at that. Then just in terms of, other sort of common deficiencies, we've observed, advisors that presented historical or back-tested performance data without complying with certain of the prohibitions mentioned in prior no action letters and other guidance, even when the firm's policies and procedures required them to do so. So I think, just sort of bread and butter, we're going to be looking at, is what you're disclosing and in the form that you're disclosing it to investors or prospective investors consistent with what you're actually doing. So fairly straightforward. And then just making sure that there is good record keeping and good policies and procedures around those statements.
So Jennifer, Sam touched upon how the new rule really codifies decades of no action letter and staff level guidance, including associated with the portability of performance data, which Kristin was just talking about. And track record presentation definitely is a common topic of conversation for us with our clients. What challenges are you seeing in this space, including if you have any thoughts around presenting kind of valuations of harder to value assets?
Well, on the subject of ported performance, portability of performance, the new marketing rule overlaps in many ways with the global investment performance standards, or GIPS. So it's relevant to consider the challenges that the challenges with ported performance to GIPS verifiers, the professionals that are performing the verification for firms that claim compliance with GIPS. So the marketing rule and the GIPS standards, there's the three primary portability tests, but each can pose certain challenges to the verifiers. Number one, when you're looking at if all of the investment decision makers are employed by the new firm, Kristin mentioned that, I think that this test is challenging because you need to evaluate who played a key role in the management of the portfolios aside from the portfolio manager. Was the strategy managed by a single manager or multiple managers? And what about the roles of research development staff? Did they move to the new firm? Some things that cause the test to be a bit tricky. And then the second general portability test around the decision-making process and whether or not that was substantially the same with the new firm. A GIPS reviewer will seek to understand if there was a model underlying the investment strategy. If there was the model replicated at the new firm? And likewise, some other questions can surface with valuation decisions like you alluded to. Illiquid investments, if they're a material part of the strategy, have they been valued consistently? Think about an instant where during one period of time, the investments were valued internally, and another period of time, they were valued by a third-party pricing service. we need to look at that and make sure that it was consistent over time. And then the third portability test regarding the records and that there are records to support supported performance. Can the verifiers recreate the returns from the records that are available? So in sum, the three portability tests are indeed challenging, but firms that claim compliance with GIPs may already have a head start on facing some of those challenges.
That's great. So I think we have just a few minutes left here, and I wanted to throw it out to everyone to give really one thing that you think everyone attending the conference should keep in mind as we head towards, and it really, I feel like it always is incredible. This event comes in mid-May. We're almost halfway through the year. So as we head towards the second half of 2021, and as I said at the outset, we'll give the SEC the last word here. Jennifer, let's start with you. What is the one thing that's at the forefront of your mind as we head into the last 7 months of 2021?
Well, I guess I'll refer back to Archegos a bit, and I will be eager to see any publications from the Treasury's hedge fund task force. The task force had been dormant since 2016, but is being reestablished to study and develop recommendations concerning the risks and vulnerabilities from hedge funds. So it may not be long before they publish at least a notice that is seeking public comments, and I'll be eager to read that.
Sam, what is the one thing that is on your mind as we head towards this back half of 2021?
The one thing on my mind relates primarily to private funds. And I think the last 4 years we've seen, I think, a focused effort by the SEC to place a much greater emphasis on the exam program for policing misconduct at private funds. There are a number of reasons for that. I think priorities, resource limitations. But I think past 4 years, if exam, and we're not talking about big fraud, we're talking about more technical violations. But I think in the past 4 years, if you had a technical violation, you remediated it effectively, paid back any excessive management fees or expenses, no guarantees, but there was a good chance that would be the end of it. I think that is likely to change going forward. I think that we're likely to see, and all you have to do is look at the private fund risk alert that the exam team put out back in June of last year. They're still looking for misconduct of private funds. They're still finding a lot of it with respect to conflicts of interest, fees and expenses, valuation, MNPI. It doesn't take much to take those deficiencies, refer them to enforcement. And I think that there's a really good chance that that's what's going to happen.
So Sam, it sounds like kind of back to the future, so to speak, potentially back to the Mary Jo White, Andrew Seresny SEC, which I know I lived through in person. An ominous word. We shall see, though. Kristin, we'll give you the last word. What is the one thing on your mind for the second half of 2021?
So I'm going to maybe take it in a slightly different direction because there's so much that we're focused on, I think, in the exam program. And I know this panel was meant to cover kind of the gamut. So I think if you want to get a good feel for kind of what's on the mind of the collective mind of the SEC and in the Division of Exams for the rest of the year, please check out our exam priorities, which are on our sec.gov site, because they do cover all 5 of our programs. They cover all of the priorities that we have in the advisor space as well as the broker-dealer space. And we've also, as Peter mentioned at the beginning, been kind of prolific recently with all of our risk alerts. So we just issued a risk alert on ESG, on AML, on digital assets. So I know those are all kind of hot topics. And we issued a number of publications kind of during the pandemic and pre-pandemic on cybersecurity risks and what we're looking at in the exam program. So if something were to keep me up, I think, we cover a lot. One thing that is, and I know we had a panel earlier in the day about it, but just cyber risks for registrants. We've seen a huge uptick in ransomware and other types of attacks, I think, while we've been on this period of remote work. So that does keep me up at night, but a lot of the other things in our priorities do too. So I would highly encourage you to take a look at those.
Well, good reading for everyone. Homework assignments, I suppose. Thank you all for a great conversation. Bruce, we'll turn it back over to you.
Thanks, Peter. Terrific job and a great panel. Our next panel is on insider trading. It'll begin at 3 p.m. Pacific. We'll see you back here in 5 minutes. Thank you.